Bonsoir. Good evening. Before welcoming friends and colleagues that are present in the room, I would like to apologize for our friends and colleagues who were waiting for us on the platform. This is typical of Parisian life. We enjoy the streets and we always arrive at meetings with a short delay. We normally enjoy the streets because we have sunny streets. And yesterday I was a bit concerned by the weather. The weather in Paris was extremely sunny, and I thought that it was not very good for us because we would have a strong competition. But thanks God, it's raining, and I'm sure we'll be all concentrated on the topic of the day, which is a war against states. So welcome to all of you. We are very happy to welcome you at Alérion. And very happy to welcome you with BSP. BSP and Alérion are two independent law firms, BSP based in Luxembourg and Alérion in Paris, independent with a very strong international culture. I would like to present the speakers today. We have on my left Laure-Hélène Gassiot, partners with BSP. Laure-Hélène is involved in commercial disputes and international arbitration, along with enforcement of awards. Fabio Trevisan, partner of BSP, head of dispute resolution section at BSP. Fabio has a very long-standing practice of international disputes, litigation, arbitration, and enforcement of arbitration awards. And we know each other since many years and are very happy to organize this event today. And then Audrey Sir is a senior associate counsel with BSP with strong practice in litigation and arbitration and also commercial contract activities. And on my right, Marilyn Bartoli. Marilyn Bartoli has a long practice in international arbitration, and Marilyn joined us 2 years ago to develop international arbitration and international disputes. This is our team today that welcomes you. And as a starter with the topic of the day, I would like to evoke a recent award, which is the award rendered in the matter of the Sultan of Solo, which is a kind of, at the same time, a bit exotic and a bit sensational award. It's interesting for us because it illustrates very well the flexibility of arbitration with regards to issues related to time and space. Time first, because as you see, this matter relates to a contract signed in 1878 between the Sultan of Solo, a territory in the north of the island of Borneo, north coast of Borneo, with English and Dutch gentlemen for the exploitation of natural resources of the Sultanate of Sulu. The rights were assigned to a company, and the company assigned its rights to the state of Malaysia at the time of independence of the state of Malaysia. But then, as is history in this part of the world, in 2013, there was an armed rebellion against the state of Malaysia. And due to the rebellion, the state ceased to pay the rental to the heirs of the Sultan. The heirs of the Sultan tried to solve their dispute with the state of Malaysia, and they went to the contract. And the contract had a strange dispute resolution provision that stated that the dispute should be brought for consideration or judgment of Their Majesties Consul General in Brunei. that was in the end of the 19th century. The ruling power was the British Empire, so that the heirs went to the British authorities. The British authorities declined jurisdiction. The heirs went to the Malaysian authorities, and guess what? Malaysian authorities declined jurisdiction, and then it was very difficult to find a solution. And they remembered that at the time of the signing of the contract in 1878, Borneo was still part of what was famous to be, on the 16th century, the empire where the sun never rests. That was the Spanish Empire. And the heirs of the Sultan had the idea to go to Madrid and ask to the Spanish judiciary to appoint an arbitrator. And the Spanish High Court appointed Dr. Gonzalo Stampa as sole arbitrator, and Gonzalo Stampa took the case. He faced many procedural attempts from Malaysia to challenge his appointment, and decided to move his seat to France, and rendered a few weeks ago an award, a big award, $15 billion, that will be probably a challenge before French courts. I see Andrea seems to be aware. It is. It is, and the appointment of Gonzalo Stampa is challenged before Spanish court, and there is also ongoing proceedings in Malaysia. So this is also a very good example of resistance of states against arbitration, and perhaps, Fabio, a good introduction to the topic of the day.
Thank you, Jack. That was fascinating to see. Only as a starter, only the appointment of the arbitrator was immediately challenged. But once you have an award, like in this case, against a state, you would wonder, well, I have already achieved something. I have an award. It grants me money, and I have a deep pocket defendant who will, of course, abide by that such award. Well, this is usually not the case. And what we will try to explore today is in our intention to show what is the situation when you have an award and you try to enforce it against states. What is the menu of difficulties, of obstacles, of problematic situations that a state can throw at you, and sometimes not only the state but also supranational bodies. We will see that. Those difficulties can be of a very diverse nature. They can sometimes have legitimate grounds, and sometimes maybe less legitimate. And of course, these experiences that we will explain today, that we will express today, are all the fruit of our experience. They are the fruit of the cases that we had in the past. And of course, those are a sample of what can happen when you enforce an award or try to enforce an award against states. And of course, at the end of our presentation, we will love to hear your input, your questions, your observation. But first of all, one of the main situations you will encounter is the delay. And Laurelène will start speaking about the delays.
Well, first of all, just to clarify, our intention here is not to prosecute states. Indeed, sometimes the delay can be a strategy for a state to prove its own position. To give you a concrete example, there was in December 2013 an award which was rendered in favor of an investor, about 500 billions, if my recollection is correct. In this case, obviously, the investor directly started to try to enforce the awards. But the state considered that there had been fraud in the arbitration. So in 2016, the state applied for the setting aside of the award on the basis of the fraud. However, the competent court refused to set aside this award, saying that there was no proof of the fraud and of its impact on the arbitration. Therefore, the question of the fraud became central in the enforcement of the award. Parallelly, it should be noted that there were still proceedings ongoing in front of the competent court to try to continue to set aside the award. But each time, the competent court would say, res judicata, I don't have new elements, I cannot look into this. So really, the question of the fraud was really looked into for the enforcement of the award. But there's a distinction which must be made, because if the fraud is only on the quantum, then it does not require the non-recognition of the award. But if and it will only be a question of further proceedings between the parties. But if the fraud is on the award itself and on the way it obtains the award, then indeed it should not be recognized. Some countries did not look into all of those allegations and just recognized the awards. In this case, it was Italy, the United States, and the Netherlands. Some other countries, the debate was instaured. For example, in the United Kingdom, where the London courts said that there was a prima facie fraud and that they wanted to have the parties file briefs on this question. Weirdly enough, there was a withdrawal of the investor of his request to recognize the award. In 2019, new elements were discovered by the states, which confirmed that the allegations they had been making since 6 years were grounded and that there was a fraud in obtaining the awards. This had an impact on the ongoing proceedings, such as Luxembourg, where there was a criminal complaint which had been filed, and the courts decided to stay on ruling both on the validation of the attachment as well as on the recognition of the awards. And also in Belgium, where here the courts annulled the exequatur and said that the fact that the new elements were not known during the arbitration proceedings prevented the states from being heard and demonstrating fraud. This case is interesting because it shows also that the courts now tend to go in a more in-depth review of what happened during the arbitration. And here I turn to you, Jacques, because I understand that there was a case, well, there has been a decision handed down recently in France where a lot of discussions are on this case.
Indeed. Indeed, it's a very recent decision. It's a much awaited decision, I should say, in the Belocon matter. We had a decision rendered last week by the Cour de Cassation that confirmed the analysis by the Paris Court of Appeals, which is very close to your jurisdiction's analysis. In this matter, Mr. Belocon tried to enforce a $15 million award rendered in 2014 against the Kyrgyz Republic. There are seats on the front line, if you like. Under a treaty between Latvia and Kyrgyzstan. The arbitral tribunal rejected the allegation by the Kyrgyzstan that the claimant had engaged in money laundering activities that violated Kyrgyz law. But the Paris Court of Appeals found these allegations convincing and annulled the award on the ground of violation of international public policy. Therefore, the analysis by the Court de Cassation was much awaited because we had plenty of decisions by the Paris Court of Appeals, and we were all very impassioned to see the analysis by the Court de Cassation, and here it came. The Court de Cassation approved the Court of Appeals And this was very interesting because it approved the position of the Court of Appeals, considering that money laundering is one of the principles which violation cannot be disregarded by French legal system, and as such is a part of international public policy. The Cour de Cassation also confirmed the use of red flags test by the Cour d'appel, what we call faisceau d'indices graves, précis et concordants. And here the red flags were mainly the abuse of corporate assets, inaccurate relations between the son of the president and Mr. Bellocon, the conditions of the tender, and the lack of reliability of an audit report. And the Court of Appeal also considered the success of the bank in a very short period of time in a very poor country. So these were many red flags identified by the Court of Appeals, and this methodology is confirmed by the Cour de Cassation, which is very close to what you have in Luxembourg. And also what is interesting for us in France is that the Cour de Cassation confirmed that the fact that a party did not raise the issue of corruption during the arbitration is completely irrelevant. So this is very important for us. And we can say here that the state benefited of an evolution of French case law that will be confirmed very strongly. And of course, there is clearly a strategy here of the state to delay things and to use the evolution of case law and evolution of international public order. But perhaps, Marilyn, you could comment more this evolution.
Yes, thank you, Jacques. I will just wait a few minutes so that the slide can follow. Well, this is a good introduction to what happened in French law. We are mostly speaking about the cases we've been involved in for the time being, but here I'm going to say a few words about a case I have not been involved in, and some of you know better than I will never know myself. I'm talking about the Yucos case. But this case, we have to speak about the Yucos case when we are considering the obstacles to overcome to enforce an award or any decision under French law against a state. We all followed, I believe, the twists and turns of the Yucos case. The enforcement of the award in France and in Belgium, and maybe in other jurisdictions, but the French and Belgium examples are very well known. The enforcement of this award led to a change in the law governing the state's sovereign immunity from enforcement, at least unofficially, but it is written in every good article on the subject. I will summarize the Yucos case because I think you all know the main features of the case. Yucos used to be one of the largest oil and gas companies in the world, and in 2003 or 2004, the Russian state started criminal proceedings against Yucos based on allegations of tax evasion, and ultimately it led to the bankruptcy of Yucos. The shareholders, former shareholders of Yucos, brought claims before several jurisdictions, and in particular, quite important claim before an arbitral tribunal seated in The Hague under the aegis of the Permanent Court of Arbitration. And in 2014, 3 awards were issued by the arbitral tribunal ordering Russia to pay a $50 billion compensation to the shareholders, the former shareholders of Yucos. You all know this. We put some dates on the slide behind me. The main dates, because there have been many proceedings in this case. We only put the proceedings regarding the challenge brought by the Russian Federation before the courts of the seat, the Dutch courts. It's interesting enough because in 2016, the first instance court set aside the awards based on a challenge of the jurisdiction of the arbitral tribunal, essentially. And then in 2020, the Court of Appeal overturned this decision. And afterwards, the Supreme Court overturned the Court of Appeal's decision, and the case is now pending before the Amsterdam courts. And while there was this whole saga before Dutch courts, we had the enforcement proceedings ongoing in France and Belgium and in other jurisdictions. In France, a lot of enforcement measures were brought on symbolic assets, such as the Orthodox Cathedral in Paris, which is just a few meters away, but also on a number of different properties owned by Russian entities, Russian companies. Well, and at the time, French law regarding sovereign immunity, sovereign state immunity, was mostly established by case law. And I mean, in parallel of the Yucos case, it may be a coincidence, but the French authorities decided that it was time to enact a law governing clearly, setting the principles of state immunity. The Loi Sapin II law, which was supposed to deal mostly with transparency and anti-corruption, was amended to include some provisions regarding state immunity, and especially state immunity from execution. And the major, because I have to to be careful, the major modification was that the creditors, to enforce an award or a decision against state-owned property, have to obtain a prior judicial authorization before attaching the property. Usually, it's the other way around. You attach the property, then you have adversarial proceedings before courts, and the court decides whether or not you could attach the assets. Now, we have to obtain a prior judicial authorization. In Belgium, the modification of the law was in the same direction. And to be authorized to attach or seize the assets, the conditions were strengthened. You need to have an express waiver of the immunity by the state, or to prove that the property was specifically reserved to the claim, to the satisfaction of the claim, or when you have an award or judgment, you have the commercial activity exception, but which is very restrictively defined. So the main thing in this change, the main lesson learned by every practitioner at that time was that the immunity was reinforced, and that it would be very, very difficult to prove that the assets you were targeting was not covered by immunity, and that you could enforce the award. In 2017, Yucos shareholders abandoned the enforcement proceedings in France and in other jurisdictions, such as Belgium. And then other cases were affected, and this is a transition to your presentation, Jacques. Other cases were affected by the change in the law. Just to make this transition work, I have to add an information, because what I said was concerned the general immunity over public assets or commercial assets. But there was a specific provision in the Sapin law regarding assets of diplomatic missions, so the immunity of diplomatic property. And this immunity has followed specific rules since the Sapin law, and maybe I should leave the floor to you, Jacques.
Thank you, Marie-Hélène. Yeah, that's the Commis Simpex example, I assume. There is someone in the room who knows the case much better than I do, and perhaps at the end of the presentation he could say a few words during the Q&A session. But this case is emblematic of what the resistance of a state can be against an enforcement of an arbitration. In this matter, we are talking of works performed in the 80s. So you can imagine the impatience of the creditor. And the Comis Impex company obtained 2 awards. The first in 2000, but it was not enforced by the state of Congo. There was a protocol. The protocol was not respected. There was a second award in 2013, and then started a long procedural saga, most of which I assume most of you are aware of, because there has been plenty of case law on this matter. But it's very interesting because it shows that a state can follow plenty of different strategies to avoid the enforcement of the award. And in this matter, amongst a large variety of strategies used by the state, we had at least 2 examples. The first one was the liquidation the attempt of liquidation by the Congo of Comis Impex. Comis Impex was a Congolese company, and the Republic of the Congo, in order to avoid the enforcement of the award, suddenly decided to liquidate the company, and they invented a tax debt. And guess what? The tax debt happened to be exactly, or more or less exactly, the same amount as the award, which is a bit obvious as a strategy. And then they liquidated the company in Congo. They appointed a liquidator and tried to obtain the enforcement of the liquidation decision in France. And the French judge, confirmed by the Paris Court of Appeals, decided that the liquidator lacked impartiality, and that there was clearly a violation of the right to be heard. And France denied the enforcement to the liquidation decision, and a similar decision was taken in the US. So this attempt was set aside by French judiciary, and then we had other attempts by the Republic of the Congo to avoid the enforcement of the award. And the one that I'm sure you all know was the procedural saga before the French judiciary about the notion of immunities. And here, the Congo benefited of the evolution of the French doctrine on diplomatic immunity. The first step, let's say, not the first step because it's a long story, but if we want to summarize, we could say that the first step, the French doctrine was that diplomatic immunities could not be waived by a general waiver, but by a general declaration which should be both special and express. That was the traditional doctrine. But when Comis Impex attached the bank accounts of the diplomatic mission of Congo before the UNESCO on the basis of a general waiver, the Cour de Cassation first remained in the same doctrine, but later the Congo benefited of the evolution of the doctrine of the. There are seats in the front line, if you wish. And we had the first reversal of the Cour de Cassation doctrine by a decision on May 13, 2015, by which the Cour de Cassation considered that a waiver to immunities required an express but not a special waiver. But then happened the Sapin Act that Marilyn commented, And we had a second reversal by the Cour de Cassation on January 10, 2018. And then the Cour de Cassation surprised everyone because they decided that the Sapin Act could be retroactive and should apply in this matter to the immunities. And the Cour de Cassation decided that the instrumentalities attached were used in the diplomatic mission of the state, and as such, a waiver to the immunity required an express and special mention. And Comis Simpex lost his attachment. So it shows how the and I think that probably in this matter, this example is probably the worst example ever of strategy of a state trying to avoid the enforcement of an award. But Audrey, perhaps you have other examples.
Yes, indeed. I have an example that immediately jumps to mind. It is a case which is pending in Luxembourg, but also in France for several years now. An award was handed down in March 2013, ordering a state to pay to an investor around $1 billion. In Luxembourg, the investor obtained the confirmation of the exequatur order by the Court of Appeal after more than 2 years of proceedings. Then the investor moved to obtain the validation of the attachment. The only party which is fighting here is the state's sovereign fund, which has been qualified by the French jurisdictions as an emanation of the state and which hold the state's assets. Since the beginning of the enforcement proceedings, the sovereign fund is trying by all means to delay the enforcement proceedings by requesting more time to file his brief, by suddenly changing his lawyer just at a time where the instruction of the case could have been closed. It also challenged the qualification as emanation of state. And in parallel, despite the fact that the law of the state where the award was handed down prohibits any recourse against the award, the Court of Appeal of the seat of arbitration decided to set aside the award. The sovereign fund immediately used this decision to delay more the enforcement proceedings in Luxembourg and ask for a stay of the proceedings until a decision is handed down by the Supreme Court that was seized by the investor. First decision was handed down by the Supreme Court, suspending the enforceability of the Court of Appeal decision. And when it realized that its chance to win before the Supreme Court were very low, the sovereign fund came up with a new idea. Despite the fact that the exequatur order was served on it, and after having exchanged a brief in the validation proceedings for over 4 years, it decided 7 days after the decision of the Supreme Court was handed down to file a tierce opposition, which is a recourse initiated by a third party to proceedings against the decision of the Luxembourg Court of Appeal confirming the exequatur order. It obviously used these proceedings as a new argument to try to obtain a stay in the enforcement proceedings. The tierce opposition is currently challenged by the investor, which considers it as abusive as the sovereign fund was, as the exequatur order was served on the sovereign fund, and it can therefore not be considered as a third party to the proceedings. In my opinion, the only way to proceed would have been for the sovereign fund to challenge in due time the exequatur order. It is interesting to note here that this is actually what the sovereign fund did in France. But we look forward to see if the courts opine to this.
Yes, Audrey. If such imagination was not sufficient, I understand the state is now invoking a decision handed down by the European Court of Justice.
Yeah,
that's right?
This is correct. And even if this decision was handed down in the context of proceedings pending before the French state courts, it seems very likely that defending states in arbitral proceedings will use this decision too. It seems, however, important to immediately underline that this decision was handed down in the very specific context of the Iranian sanctions, and it remains to be proven that such decision can apply to other sanctioned countries. But maybe, Jacques, you could provide us with more details on this decision, which may lead us to wonder whether sanctions can become a mean to resist enforcement.
Yes, Audrey. And probably the issue of sanctions is a matter we all have in mind, given what is happening now in Ukraine. And we will probably have plenty of cases related to the Ukrainian war. But here, the sanction at stake are the Iranian sanctions. And in this matter, we had two American companies which were victims of fraudulent acts by an Iranian company, the Iranian bank SEPA, which was subject to sanctions. The Iranian bank SEPA was condemned to a $4 million ruling, and the two American companies tried to enforce this award. They awaited the lifting of the sanctions to attach the effects of their debtors, and when they attached the assets, they also considered that they were entitled to receive interest for the period during which the assets were, let's say, protected by the sanctions. And this was an unprecedented question before French courts, before French judiciary. The French Cour de Cassation turned the question to the European Court of Justice, and the European Court of Justice rendered its decision on November 11 last year, and said that EU regulation must be interpreted as precluding protective measures against funds and economic resources frozen due to sanction without prior authorization from a competent national authority, even if the attachment does not remove the assets from the debtor's possession. And here it was considered that the attachment permitted the creditor to be paid on a priority basis. This, well, at least in France, it can be questioned, but at least this was the reasoning of the European Court of Justice. So sanctions in a case like this may be a mean to avoid sanction. Of course, well, to be fair, we should be fair with the European Court of Justice, because probably it was a way by the European Court of Justice to avoid having state trying to protect assets by organizing fraudulent awards or fraudulent decisions and trying to enforce fraudulent decisions. But it opens the door to having sanctioned entities using, or we should say abusing, of sanctions to avoid the execution of arbitral awards. because now states can invoke sanctions to as a defense to challenge the enforcement of arbitral awards. So this is interesting at a moment when we consider sanctions, but it's also interesting for all of us in the room who practice law in the EU. And probably, Fabio, you could say a little bit more about how EU law is used by states in this kind of situation.
Thank you, Jacques. Yes, indeed. As I was saying before, the European Union, in several ways, intervened in the past in arbitration proceedings in several ways. In 2018, of course, you all know that there was a ruling by the European Court of Justice which clearly ruled that investor-state arbitration clauses in intra-Europe countries, BITs, was incompatible with EU law, as it impaired the European Court of Justice exclusive jurisdiction to interpret EU law and thereby undermine the principle of autonomy of the European Union. Clearly, this had a major impact on BIT arbitrations and definitely on the case at hand, because enforcement was simply stopped. That was the Achmea decision. The Achmea decisions nevertheless left some doors open. It remained unclear as to its intended scope and application. And this is why, shortly after Achmea, the European Commission issued a non-binding communication setting out its own opinion that all intra-EU BITs and intra-EU investor-state arbitrations under the ECT, under the European Charter, were incompatible with EU law. That was the Commission interpretation and the Commission intervention. Now, the Commission intervened also in another case, in the Mikola case, by going as far as issuing a decision which has forbidden Romania to pay the damages awarded by a enforceable award. And this decision was then challenged in front of the tribunal, and the tribunal said, indeed, you cannot apply EU law to Romania, who accessed of course, the treaty in 2007, while the arbitration was started before. Now, very recently, in the Eurofood case, the court said no and has overturned this decision and said that it doesn't matter because the arbitration was handed down after the accession of Romania, and therefore the payment gives rise, in its opinion, to a state aid. So this opens, of course, the door to not having the possibility, while the investor has a valid award, to obtain payment at all. And that is because of the intervention of a supranational body who uses the interpretation of the treaties to forbid payment and to make sure that those BITs which are valid and which were denounced only in 2020, so while the arbitrations were ongoing, those BITs were actually in force, but according to the interpretation of the European Court of Justice and the Commission, of course, they should not be applied because they contravene the treaty by itself. So one can wonder if this is not a breach of the European Convention of Human Rights, because you are not able to enforce a valid judgment which is based on a valid treaty and which clearly is unenforceable. So that opens other avenues probably, and definitely the last word is not said, and there is definitely much more to come, and it's really interesting to follow. Now, on this note, I would like to open up the floor, questions to the floor, open up observations from you, or maybe your own experience. We already have questions.
Andrea,
just one very short on the
take the mic for the platform.
The very particular thing in the Mikola case is that Romania the state, the losing state in the arbitration is willing to pay.
Absolutely.
It is the European Commission and the European Union that prevents it to pay. So delay is not always at the initiative of the state.
Well, Romania initially did delay and then
Initially,
decided
yes.
to pay, which of course was its own decision. But the European Commission intervened, stating that they would open a case against Romania if they paid. Any other questions? You're mostly welcome, or observations, or stories, experiences.
War stories.
War stories.
War stories are mostly welcome.
Anybody?
We have a question.
Yes?
No, it's not really a question. I fully agree with your presentations that there's a lot of obstacles led by all courts to the enforcement against states. But in my opinion, I don't know if it's a war story, but there's still a lot of windows opened and possibilities to enforce against states. What we can see from your presentations that the courts tend to go in one direction to prevent enforcement, and then they see that it doesn't work, so they change their mind or they use another tool, and then they do something else. And that's the. I'd like to be optimistic.
Yes, and definitely we are speaking about all the cases that went wrong for the investor, and I'm sure there are many other cases, and we would be interested to hear about which went well. But indeed, what we see recently and the recent developments, and by all means, as we said initially, sometimes the means to resist are valid means. For example, if there is an accusation of fraud, of money laundering, well, that should be looked into very, very seriously, and that sometimes gives ground not to allow the enforcement. We do.
And just a remark of optimism is the fact that states, most of them, especially the big ones, you mentioned the Kazakhstan case, the Yucos case, or other states have assets all around the world. So it is sufficient that only one state does not oppose to enforcement to be successful on the condition that there are sufficient assets. So the strategy to enforce an award against the state is of importance. You have to pick and choose the state where you want. Of course, tracking assets, find assets is important, but also from a legal point of view and from an enforcement strategy point of view, it is important to find the states you want to go for various reasons. You go to the US, it's very long to go to the US because you have to. It's not like us in France where you obtain the exequatur ex parte in 3 weeks. In the US, you first have need the confirmation is adversarial proceedings. You can go up to the Supreme Court before you can start making an attachment. But there are also interests to go to the United States. You have the discovery, where states are obliged to disclose the existence of all their assets worldwide, which is very valuable for a creditor. So the strategy is very important. And what we see in cases, recent cases, is that the strategy change. For example, the targeted countries are different. You see in the static Kazakhstan case, well, maybe Belgium was a mistake, but there was a big asset there. But they tried the Netherlands, they tried Italy, quite successfully, Italy. In Yucos, these countries were not targeted at the beginning. They choose different ones. They choose, for example, France very heavily. You said this. In June 2015, they made a massive campaign of attachments in France, starting against Kazakhstan. Did not even try France for obvious reason, maybe, but especially because, well, one of the reasons can be fraud and the assessment of public policy. We have seen it with the Balkan case. In other countries, for example, in Switzerland, the public policy is not even assessed. If the arbitrator said there is no corruption, there is no fraud, there is no money laundering, the Swiss Federal Tribunal will never look at it. It will be satisfied. Of course, the line of case law can change tomorrow, but this is the situation. But why then nobody goes to Switzerland?
Because you can't enforce against states.
You can.
Unless you have a Swiss angle.
Unless there is a link between the Switzerland and the case, or investment arbitration, which is never the case because it's always a foreign state. So
in Switzerland, the situation is very simple in a way, because you have a very old case.
For the platform, we need
sorry. No. Just in order to give an answer to your question, why not to go to Switzerland? The situation is very simple in Switzerland. If you are a creditor with an award or with a final judgment, and if you are a Swiss creditor, you can go to Switzerland, no problem. But if you are a creditor from another country than Switzerland, there is a very old case law, something like 80 years old, which is still valid in Switzerland. And in order to enforce, you have to give an evidence of a link between the creditor, the company which want to enforce, and Switzerland, or you have to give an evidence of a link between Switzerland and the state indebted. And if you don't give this evidence, you cannot enforce in Switzerland. But very simple.
Hi, my name is Laura Hallan, and a couple of examples of war stories to make a hopefully optimistic point that we can get somewhere with this. And the first is from years and years ago when I was representing a state and the arbitration was just starting. And the claimant went before Dutch courts to get a temporary attachment for the duration of the arbitration. And they tried to attach the embassy building and the funds, the accounts of the diplomatic mission in the Netherlands. And we went, our co-counsel in the Netherlands went very hard to argue before the court that the monies could not be attached because they were used for diplomatic purposes. And the court did a very surprising judgment. They accepted our argument on that, and then they maintained the attachment on the embassy building, saying that, well, you don't, because you can still obviously keep using it, so the fact that it's attached as property does not impact the running of the diplomatic mission. And this was just hugely embarrassing for the state. And it's a similar thing with, I wasn't personally involved, but my colleagues were with the Walter Bau versus Thailand saga, where one of the assets they enforced was the private jet of the Crown Prince of Thailand. I think this was attached in Germany. And the point there again was that jet itself wasn't worth so much money, but it was to put pressure on those in power and those taking decisions in the state to try and get them to pay up voluntarily. So this can also be a strategic consideration, that it's not that the asset itself, well, first of all, we might think, in the end, I'm not going to be able to enforce against this asset, or then even if I will, it's not going to be worth that much. But it's just to create embarrassment and inconvenience enough, maybe personally, if it's a regime that depends on certain people and their decision making, or then the country more generally, to get them to voluntarily pay up.
We have a colleague representing states in the room. No special questions. Yeah, but you may have war stories actually.
I don't want to incriminate my client.
No need to incriminate your client.
But it is true from my experience that we have many awards, not awards, but foreign judgment, which was handed down in the Netherlands because I represent the state of Iraq, and many judgments were taken in the Netherlands, where it was very easy, as you confirm, to obtain a decision, mostly by default, because the process of notification of service was often, very harsh against the state or the defendant in the Netherlands, and that's why there was some forum shopping, and then most of the creditors went there to obtain judgments. So yes, I confirm that. I'm pretty amazed about the attachment of the diplomatic buildings. It's forbidden by the Vienna Convention. But yeah, that's what I say. It's easy to get an attachment. It used to be, at least, in the Netherlands. Yeah. There's another colleague of mine which may confirm, maybe. No. Yeah, it's me. Take it back.
Yeah, in the Netherlands it was the case before, but today the Supreme Court is very pro states, and it's very difficult even for buildings which are. We have a case like this, which are squatted, so they are not. It used to be an embassy, but they're really not at all. There are squatters in there, and you still cannot, because in the Netherlands you have first to ask the ministry for it. It's a different way than in France. You have to notify to the Ministry of Foreign Affairs that you want to attach a state asset, and then they systematically oppose by saying, it's sovereign, because it used to be an embassy. So it's not the case anymore. The Netherlands are not a good. Currently the policy is not. It's not an easy state, but there are default Dutch judgments, but it's because in the Netherlands you have a forum arrestee still. So if you have indeed an asset in the Netherlands, and I think that works, for example, for ships, because that was historically the case. If you find an asset, you can start proceedings on the merits against the state, which then it's helpful because it's an EU judgment. And but I agree that notifications with countries like Iraq are difficult also. So
there are two questions.
Just a question regarding this Loi Sapin 2. Was there a test of compatibility in the French Parliament with the New York Convention? And is it compatible?
Well, the New York Convention does not provide for any prior judicial authorization, so I guess this is the reason why you're...
Sorry, no, I was just saying that New York Convention on the recognition of enforcement and the recognition of arbitral awards.
Not the UN Convention on jurisdictional immunity.
This question was asked, I'm a Swiss lawyer, so in Switzerland, the Swiss Federal Supreme Court said it was compatible, the test of the close link with Switzerland, that is just case law of the Swiss Supreme Court. They said it was compatible to apply this test with the New York Convention. And I just wanted to know if, that was thought through.
I have maybe the answer. You are mentioning, but your answer was okay. But I will try to elaborate a little bit more. You're mentioning the Uzbekistan decision of the Swiss Federal Tribunal, which confirms the link. In France, the Loi Sapin II has nothing to do, I think, with the New York 1958 Convention, because the 1958 Convention only concerns recognition, which is the authorization to enforce, but not the actual enforcement. And I think it's Article 1, paragraph 3 of the Convention that provides that enforcement measures are governed by domestic regime, which means that, of course, it's outside the scope of the Convention.
And I'd like to say one word about diplomatic assets, because I heard before that it could be shocking that diplomatic assets could be attached without at least any specific waiver of immunity. If on principle, I think everyone in this room can agree on this, the issue that creditors face, and you may have understood that I represent creditors against foreign states a lot, is that what is a diplomatic asset? Is it an asset that the state say is diplomatic? Because to give you an example, when you go to a bank in France and you attach, the bank says I have an account. It can say I have an account opened by the embassy, but who said it's the embassy that opened the account? That's the state. So it is enough for the state to say when it opens an account in France that it is a diplomatic account to be covered by the diplomatic immunity and then being impossible to seize. And to give you a practical example, we once, it was before the loi, we once attached a account of Asian states that declared 42 accounts, all diplomatic, 42 accounts. And the court refused to see beyond the name. It settled and we didn't go before the Court of Appeal. But, and this is the same with diplomatic buildings. You have a building, who knows what's inside? Because if the bailiff goes inside, he may lose his license. But when you manage to gather enough proof that it's not, I mean, what I want to say is that the state can have just put a plaque at the bottom of the building and say this is the service of the embassy, and then no one wants to enter because the bailiff will lose its license. But when you manage to gather some evidence and you enter the building, you realize that it's not. And how can you provide this evidence? It's extremely difficult, and that's an issue. And I'm talking about France, but it's an issue throughout the world. The Cour de Cassation on its case law regarding diplomatic immunity, so you said that you need a specific waiver. But when it was asked the question about on whose shoulder the burden of proof falls, it actually did not really reply to the question and left it quite unanswered, but seemed to, at least in appearance, seems to be on the shoulders of the creditor. And that's a real issue, because how can you prove that an account is diplomatic if you cannot ask the bank because it's got a banking secrecy? And how can you ask the state to prove something that goes against its own interest?
Well, you've said it all, but it was precisely the problem of the creditors in the Comisambex case. And in 2018, the state just had to say, okay, these accounts were open for the diplomatic mission, and that's all. They didn't have to justify anything. So yes, case law is not in the favor of the creditor. They have to prove everything and to prove it beforehand. So now they have to request a prior authorization before even going to the bank and having a listing of the bank accounts. So it's almost impossible to prove anything of the sort regarding bank accounts.
Just as a matter of disclosure, I represent Comisambex.
Yeah, I guess. But since we discussed the case and just wanted to be very clear.
Emmanuel, I refresh your memory. You precisely a few months ago attached a plane that was said to be diplomatic, and you were very successful in court to demonstrate that it was not diplomatic. So it is possible. Well, good lawyers can achieve that.
Or you come to Luxembourg. You don't have to prove to seize assets in advance that it is a court. Sorry, it is sovereign asset.
Even though Yucos came to Luxembourg, but it didn't change a lot.
It didn't. Not yet.
Any more questions? Perhaps. Yeah. Perhaps. Oh yes, last question. Of course.
Yeah, just a question. What could be the consequences of the war in Ukraine regarding the enforcement of the Yucos case, especially in France?
This is a hard question. It may be a topic for next year, perhaps, because I think it's a very wide question. Does anyone have sanctions? Of course, sanctions. Yes, but yeah, we have the issue of the sanctions, and we know now.
It's sanctions. It's frozen. If it's frozen,
the state is not under sanction now.
that's correct. But you have to make the distinction. Yes.
Just the beginning of an answer. Just the beginning of an answer, because as you know, there is a French word which is called bien mal acquis. And of course, most of the Russian assets which have been already attached in France, or which will be attached in France, are certainly in this category bien mal acquis. And if you look in the past, the situation is very clear, because you have, for example, the daughter of a former Uzbek dictator who had something like $500 million of assets attached here in France, has bien mal acquis. But one of the questions is very simple for France, because the French state will consider, look, we will keep the bien mal acquis for the state of France, and this has been the case in different previous topics. I hope it will not be the case for the Russian assets, and I hope that France will give back the value of these assets to the Ukrainian.
I think there are plenty of possible scenarios on this issue. But indeed, it's a very interesting question, but I'm sure most of us will work on these questions in the coming years. So I would like to thank you for your patience, and especially our friends and colleagues that are on the platform. I hope you could hear all the questions and all the interventions. I'm sorry we will have to leave you, because we are now going to have drinks, which is probably what you are all waiting for. So thanks to Fabio, Laura-Hélène and Audrey.
Thank you.
We have drinks waiting for us. So let's move to the other room and let's have drinks.
Thank you all.